the jurors walk out of the courthouse. Well, we're reporters. So half of them go this way, half of them go this way. I run down to give my card to several jurors. They wouldn't take it. The ones that walk this way. The ones that walk the other way, a bunch of cameras are chasing them, to be honest. And they have to wait for a shuttle bus to go back to their cars. So they're standing there. They can't really go anywhere. And that's when the other reporters started to talk to them. And I ran up and I, stuck my phone. I told Jordan he was there. I'm like, you stay here. I'm going to go videotape these guys, see what they have to say. And that's where those interviews happened that you probably saw. I played them last night. And those jurors seemed very, very kind, very wonderful. But they probably also had zero media training. I have done this for a living for 20 years, but if I had just served on a high profile jury case, I'm going to want to get my thoughts together before I walk out and have 50 cameras in my face. And that's honestly what happened. I thought they handled it really well though, but there's been one statement that I've had dozens of you send to me, and it's got people talking. This was said, a juror said this to Fox 10 in Phoenix on the sidewalk last night after the verdict. I want to play the clip and listen to it closely, and then we'll talk about it.
Yeah. Do you remember your reaction learning that she has been convicted of killing her 2 children?
I feel sorry for her. I mean, driving home yesterday, I was like, God, she's spending the rest of the next 3 lives in prison in a cell. I mean, you got to feel sorry for her, even though, I mean, that's an awful thing to do. I mean, there's something wrong up here, but what do you say? Still, you just feel awful about it.
So he said that yesterday, not today. He said that yesterday, meaning that he was driving home the night before and knew the night before they had a verdict that she had killed her kids and was serving 3 life sentences. So is it problematic? What do you think? They were under an admonition not to talk about the case. They were under an admonition not to watch media, whatever. Now, it's very possible he misspoke. Very possible. And a lot of people think he may have. I don't know. But what I did want to do is get Rachel Smith on, Special Prosecutor Rachel Smith, to get her take on what happens in a situation like this. When a juror says that, I'm going to play it one more time for you, and then I'm going to play the Rachel Smith interview for kind of get some answers. Because legally, I've had multiple people say, oh my gosh, is this a mistrial? Oh my word, what's Lori going to do? They're going to use this on an appeal. You remember, I don't know if you remember. If you weren't here 2 years ago, you probably don't. I remember because after I interviewed a juror, Jim Archibald filed a notice of appeal based on not a notice of appeal, he wanted to bring to attention a few things a juror had said to me in that interview. The juror then, after that was filed, we did a follow-up interview at his request, and he clarified it, and it ended up not going anywhere. But here again is what the juror said yesterday afternoon.
Yeah. Do you remember your reaction learning that she has been convicted of killing her 2 children?
I feel sorry for her. I mean, driving home yesterday, I was like, God, she's spending the rest of the next 3 lives in prison in a cell. I mean, you got to feel sorry for her, even though, I mean, that's an awful thing to do. I mean, there's something wrong up here, but what do you say? Still, you just feel awful about it.
Okay, so what does all this mean? Let's go to our expert, Prosecutor Rachel Smith. For those of you that might not know who she is, she served as a special prosecutor on the first case with Lori Vallow Daybell in Idaho. She's done over 100 other murder cases. She's done death penalty cases. She knows her stuff. And maybe she's seen situations like this before. Here is what she had to say. All right, Rachel, the big talk about over the past 24 hours, one of the big things has been this juror who spoke to the media, all of us yesterday, and talked about how, well, he talked about that maybe he may have seen or known about Lori's prior offenses the night before the verdict came in. We don't know if he misspoke. We don't know the context of that, but it has a lot of people raising questions. First of all, just your overall thoughts of what he said and what that could that mean anything for this case?
Well, the sign bit, the response that I would have to that juror's clip is, we don't know. Could have been a misstatement. He was exhausted. It's my understanding the jurors walked out, and there were, understandably, the reporters were trying to talk to him. They probably had very little time to get, I'm not even sure they were warned that the media was out there, or that the media could approach them. So having had reporters come up to me and ask me questions, I worked in an office where we were coached a lot about how to handle that. We literally had one of the major TV stations right across the courtyard, and the local big Post Dispatch had an office in the court building. So even then, even with exposure like that on a nearly daily basis, I would often freeze. So it is possible he misspoke. It is possible he was just tired and got it wrong. But if the statement stands that he somehow learned the night before they reached a verdict, and that he learned of the other convictions, that could be problematic, but it's not automatically problematic. In most places, and in Arizona as well, a defendant has a right to file a motion for new trial. If Lori's going to appeal, she's going to do that. In fact, everybody does that. That's not new, novel, or exciting to those of us in the field. It sounds exciting to people who maybe not follow it the way we do, but Lori has a right to file that motion for new trial. If there is concerns about that statement or evidence to suggest he learned of information while the case was going on that was external to the court trial, then that would be the place we would see it raised. And then the court would have a hearing and make a decision. One, did it even happen? And two, did it have an effect? Did it somehow affect the outcome of the case? And the state would be given a chance to respond. And in fact, if the court decides, yeah, the jurors acquired outside information, then the response would be the prosecutor would have an absolute right to deal with it. There's a couple of cases directly out of Arizona that give the standard, which is that the prosecutor then has the burden of showing that it didn't affect the outcome. So the prosecutors in Maricopa, should this come up, will have every right to stand up and say, look, the evidence was overwhelming. There's no evidence that anything he might have learned impacted how he voted, and judge, it's not the basis for a new trial. So it is certainly something that makes the situation more complicated if true, but there are legal recourses for both the state and the defendant, and an opportunity for the judge to do a hearing. So that would come up in the motion for new trial if Lori even wants to file one. So, you know, Nate, I've gone a little long, but the posture that we're going to be in over the next 60 to 90 days is Lori and or her standby counsel will have a right to file a motion for new trial. They almost all of them who are going to appeal do that. And then if that's denied, then Lori's sentenced, and then she has a right to regular appeal, which is where that issue would come up a second time, where the Court of Appeals would look at, hey, did the trial judge get it wrong? But there's a lot of deference given to the trial judge in that situation.
Well, if you recall, in Lori's first trial in Idaho, I interviewed the juror, the first juror, and Lori's defense team did file something based on a couple of statements that he made in that interview. I then did a follow-up interview with him at his request, the juror. He said, I want to make it clear. I don't recall the particular items that he raised, but this came up in that trial, and I don't think it really ended up going anywhere.
No, it didn't. And Lori limited her appeals in Idaho. She didn't file everything she could have filed. So that's a very narrow context, but it did come up prior to sentencing. Judge Boyce considered the information and it just didn't go anywhere. It wasn't as much that they acquired information about her criminal history. I don't remember the specifics, slightly different nuance, but when jurors talk after a conviction, it can affect the outcome if there isn't a clear record and if the court doesn't do a good job of running it down. Judge Boyce did allowed and Jim Archibald made a record, and Judge Boyce did a really good job of addressing concerns, and it ended up not really going anywhere. If the juror misspoke, and if it didn't, and even if he didn't, if it didn't impact the outcome and the state can show that it did not impact the outcome, it's really not going to go anywhere. It's all going to turn on that hearing.
Right. Okay. So what other things do you think the defense, should Lori decide to do a full appeal? As you mentioned in Idaho, she kind of waved a bunch of that away. But let's say they go full in on, we want to appeal this. Are there other things that are kind of standard in all of these cases? Or in this particular case, are there things that they'll really try to target when they file the appeal?
There are things that standard. They will always attack discretionary calls from the judge. They'll say the judge had misconduct, and that is a word that is often misused in the general public. It has specific legal terms, but people hear that and they get really worked up, understandably, but it's a standard. The judge got it wrong. They will likely go after something, and they almost always accuse the prosecutor of doing something wrong. That's pretty standard, and sadly, we've seen it grow exponentially over the last few years, that attack on prosecutor, the attack on law enforcement. So we're going to see that. You're going to pretty much see in her appeal what Lori objected to. She's going to claim she didn't have discovery. She's going to claim they shouldn't have been allowed to put certain evidence in because she didn't have anything, or the person wasn't qualified as an expert. So those are pretty standard, attacking the decisions of the court to let things in. I think one thing in particular that we're going to see, should Lori do an appeal, will be her argument about her statement. It was very clear that her standby counsel and Lori really thought that a different type of evidence was admitted than what the jury was given. And so if they can, they will raise that issue. The judge held the hearing. I suspect her failure to object in a timely manner may cause her issues on appeal.
You mean the exhibit of her police interview where the prosecution played snippets of it, and
Right.
Lori was under the impression that they were submitting the entire exhibit, and she even made a deal out of that in her closing argument. Please go watch the whole thing. I don't know if she realized that the hearsay parts had been taken out, but there
Right.
seemed to be a disagreement between the sides, and if the judge really understood what everybody was saying. And she specifically said, we want this flagged for appellate reasons.
Yes, absolutely. That's what, and if we looked at, I watched some of the juror interviews from last night, and one of them in particular said, well, I watched the whole thing and it's all in snippets. So that statement might give her some fodder to say, see, the description was misleading. But again, Lori's failure to preserve the record, Lori's failure to look at the exhibit and insist the opportunity to review it before it was shown to the jury. I mean, some of those things that lawyers just know to do, Lori didn't do. And she's treated like a lawyer. So I think while she made an effort to raise some of these issues, and I suspect we will see them in pleadings, an appellate court very likely will say it's not appropriately preserved for review.
If you had to guess, do you think she represents herself in the next one?
I think Lori likes being on center stage. I think she has an idea that the state has the evidence they need to convince a jury. So this will be another attempt at the Lori show from Lori Vallow.
And do you think it kind of goes same course? She cross-examines the witnesses, doesn't present anything on her own, or do you think she kind of learned in the first one and now they're going to try to get witnesses and evidence?
You know, one thing I found reassuring about this trial, I knew it instinctively. I knew it from the evidence. I knew it from her phone calls. Lori knows what she's doing. Lori's smart. Lori's capable. She just has a moral compass that doesn't even point south, let alone north. So, so I think if Lori's paying attention and interested in self-preservation, she may step back and let counsel step up. But if the judge says no, if counsel steps up, I'm going to give them more time and she just wants it done, then Lori will represent herself. So I think that's what's really going to drive it is if Lori thinks she can get help and get somebody to do what she wants, when she wants, and keep these trial dates, then Lori will take help. If Lori can't keep the trial date and get herself back to Idaho, then she'll go it alone.
Interesting point. It's always seemed to be her thing, the time. She
Yeah.
wants it done. And she has consistently raised the issue that with this second trial, it's outside of her rights of the certain time frame. Even though I think at this point it's only like 4 or 5 days now, the judge has really tried to move it along.
Yeah.
Yeah.
Yeah, you're absolutely right. She has raised those issues, but with the trial that she had with Charles, because one thing Lori could have done is asked for joinder for both cases to be tried together.
Mm.
Candidly, no defense attorney in their right mind would want that, right? If you remember, there were several efforts to sever things in both Chad and Lori's case, because if a defense attorney can get a case severed and chopped up, it makes the state's job harder. It makes admission, you're arguing about all the evidence. So Lori, however, if I were the state, I would be the judge. I apologize for the background.
I'm sorry.
We have a puppy and decided to
It's
bark.
what puppies do.
It is, and he hears your voice, Nate, and he starts
I call the
talking.
dogs.
Yeah, yeah, you do.
Oh, you're muted. Oh.
I
Oh,
was asking my
asking for
lovely
help.
daughter to
Yes.
escort the puppy out of the
That's all right.
next room over. I apologize.
All right.
But I do think that if I were standing there and she's complaining, I'm like, Judge, she could have joined him. She could have had both trials at the same time. You know, I would try to make that point with the court. I'm sure the judge, you know, I'm just envisioning Judge Boyce would look at me knowing my argument and deny my suggestion, but I would still make that argument because she had options. Her decision to speed her case along is her right, but she doesn't then get to complain about the way things are done.
Yeah. All right, Rachel, anything you want to add?
No, I'm just so grateful that the verdict turned out the way it did. And I'm really grateful that the jury saw through Lori's efforts.